Welcome to this ALTI special edition with my friend and colleague Silvia de Conca. Today we'll be discussing Silvia's PhDs, who she defended in June of 2021. And I'm delighted to be with you, Silvia, so welcome to this talk today.
Thank you. I'm very happy we're doing this.
It's actually the very first one. We have to set the standard for this discussion. So I thought what we could do is first for you to give us a sense of what your thesis is all about, and I presume that I think what would be great is for you to explain how it may impact legal scholarship, but also may integrate the broader debate regarding privacy and smart homes. So if you could take us through the journey of your PhD and explain the main idea, this would be great.
Yes, of course. So my PhD research focused on smart speakers or voice assistants, however you want to call them. So the typical Alexa or Google Home or even Siri that are now becoming more and more popular in the households in North America and Europe. And how these smart speakers affect in a certain way the way that individuals conceptualize their private sphere, how their privacy, their private dimension is affected by the presence of these talking electronic devices, and also how then the GDPR and the proposal for privacy regulation can tackle some undesired effects that might come from the way that smart speakers function and collect and process data. So it all revolves around privacy, data protection, and smart speakers. And in terms of contribution, well, what I've done is, first of all, I offer, as far as I know, one of the few complete overview of smart speakers from the perspective of the application of the GDPR and from the perspective of the application of some provisions of the incoming e-privacy regulation. So from the legal perspective, I offer an overview that systemically looks at how the GDPR concretely takes form when we discuss these devices, because the GDPR is technologically neutral. So sometimes the interpretation of certain provisions needs to be adapted to the technological reality. From a non-legal perspective, or what I call meta-legal perspective, the private sphere and privacy are concepts that originate outside of the law. They are social-cultural constructs. This means that they are multifaceted, and that analyzing them from different disciplines actually can give different results and focus on various aspects. But these aspects are all closely intertwined with personal identity and with our daily lives. So because tools like the GDPR and the privacy regulation are legal instruments that protect this social cultural construct, and necessarily also has to simplify it a little bit, translate it, if you want, into legal language. I have also looked at several disciplines from history, philosophy, and psychology and behavioral sciences, besides obviously computer design and behavioral design of digital products, to see what attributes, what fundamental understandings we associate with our home as, the container of the private life and private sphere, and how the smart speaker interacts with these attributes. And then I have discussed the legal part in the light of these non-legal behavioral, social, cultural, philosophical concepts, connecting them and in a very organic and, if you want, also holistic way. That is definitely also a contribution, an original contribution, because it is not very common in law.
So yeah, and that triggers so many questions already. The first one is, when did you start your PhD? Because it seems that I got aware about those home assistant just a few years ago. So when did you start the PhD, and did we have the GDPR at the time? because I guess we have some PhD candidates listening to us, and this is kind of the ultimate fear, right? That a big chunk of regulation will come in during the PhD and will change the entire landscape. So I'm very curious about those.
Yes, so I drafted the project and made the preliminary research towards the end of 2014 and through 2015. So at that time, only Alexa and Amazon Echo had been announced, but there were some experimental projects that some of which did not then see the light of day and did not go through. Jibo was the one that actually also triggered a lot of attention, and so it was all very well, it was a very small niche and was just beginning, and it wasn't even clear whether it was going to actually take off or not.
Because on that, it could have been that you've chosen, to study Google Glasses, in which case the PhD would have been of, no use. At least for now, it might be in the future. So you were lucky in a sense.
In part, I was lucky. In part, I really, really dug and I looked into market projections for the smart speakers. Throughout 2015, there were already several projections that said we might reach something like saturation of the European market and of the North American market by 2022, 2023. And we are kind of going in that direction, slower in Europe than probably it was forecasted. If we look outside of the Western countries, if we look at China, Russia, the numbers are extremely high, actually. The Chinese voice assistant market has one dominating and two that are kind of behind that a little bit, voice assistants. And we're talking for a total of over 500 million devices. So I think that looking at the market projections helped me because I wasn't just looking at the hype. I was looking at where the markets were investing. So it helped me steady in a certain way and I knew that was not going to go anywhere yet.
Yeah. And what about GDPR then? It did not exist at the time.
It was not into effectiveness. The draft was being discussed
Already. Wow.
and it started having an almost definitive form when I submitted my proposal. So what I did with the proposal was I assumed that the GDPR was going to be was going to enter into force during my PhD, which is exactly what happened halfway through it. And I wrote immediately the proposal focusing on the GDPR. I actually had that problem again with the privacy regulation because that one was supposed to enter into force almost together with the GDPR, and then it didn't happen. And actually, a more concrete draft of the privacy regulation was published, I think, 2 months after I had sent my definitive thesis to my committee for evaluation. And I received some criticism about that because some people that saw my thesis thought, why aren't you focusing on the directive? But it was a precise choice because I knew that the directive did not cover the technological reality of these devices. So there were too many uncertainties whether these devices would fall under the scope of the directive. While I know that whatever form the regulation is going to take, the scope will include IoT. So that didn't matter for me, and I took a risk.
Yeah. So you should have been in the future, but something also that would be interesting for the people doing research listening to us is how did you approach the other fields? Because you are a lawyer by training. So how did you approach sociology and behavioral sciences and all that? Did you read a lot? Did you interview people? I mean, what was the way for you?
I definitely read a lot and I dug a lot. No, so that was also a difficult aspect of my research, but it was also the enriching one. And personally, I'm very happy I did it. So luckily enough, there are some publications, some sources that are considered fundamental, they're keystones in these disciplines.
Mm.
So, for example, there is the history of the private sphere written by French historians. It's several volumes. It's extremely fascinating, and it is the starting point of our research, even for historians. So I moved from the keystones, the important text, and I found them by talking to colleagues from other disciplines. I wouldn't necessarily call them interview because I didn't follow a protocol, and it wasn't as structured as a qualitative interview should be. But it was more networking and comparing and asking to experts in those fields. Same for behavioral sciences and psychology. I used Arwin Altman's foundational research about privacy from a behavioral perspective. And I also got a little bit more secure and comfortable in my steps when I saw that other people bigger than and more famous and more authoritative than me were also using in their papers that were coming out while I was writing or in previous books, the same authors from other disciplines.
And so where were those people coming from? Because this leads me to the following question. Would you say your thesis is relevant outside of Europe, since you've studied, I suppose the main focus was our European perspective about, the privacy sphere. So how do you relate with other countries?
I used mostly European perspective and European authors. I also use quite a lot of North American perspective because up to a point, the disciplines of privacy and data protection intertwine a lot between the two sides of the pond. What I would say is relevant outside of Europe of my thesis is that the GDPR is becoming an inspirational standard for a lot of privacy systems outside of Europe. It is because of the relations that many countries have with the Eurozone and the fact that the GDPR has a scope, a geographical scope that inevitably extends outside of Europe. Because if companies want to do business with Europe and want to collect data for European citizens, they need to comply with the GDPR in one form or another. And this has pushed quite an interest on the GDPR, and many countries have adequacy decisions, so have regimes that are similar enough, or are taking the GDPR as a starting point to develop their own regimes. And even the United States, some states are by now looking at the GDPR and the principles contained in it and integrating them within their tradition. So from this perspective, this certainly becomes relevant, like looking at how the GDPR applies to this technology. At the same time, there is a cultural limitation because the private sphere, what falls within the private sphere, what falls within the public sphere, the acceptable norms to respect someone's private sphere are all culturally connected. And even within Europe, we see that. Because coming from Italy and living in the Netherlands, I see even just the way we use curtains in houses is radically different. So, and that is all part, that is a tool. The curtains are a tool. Respecting your neighbor's privacy is social norm. This all changes. So from that perspective, I do think that it can be interesting to see at a more general level a European tradition, but some nations might not necessarily feel that reflects their own cultural landscape.
Yeah. I'm still unsure as to what is the relationship Dutch have with their privacy, because if you've been to Amsterdam, you could just walk around, and same is true in all the cities in the country, and literally look at people's place. And I thought, well, because there are no curtains or because it's all wide open, it must be that people are not looking, through the window. But then I was told that actually people do that. So I'm a bit confused. But going back to your master's, going back to your PhD, the title of it is The Enchanted House. And so, first of all, that's a wonderful title. and very creative. So why did you pick it? Did you have any doubt as to whether this was a good idea to have such, a creative title? And what does it represent with, in relation to the object of your PhD?
Thank you. Um, well, if I have to be completely honest, what comes to my mind when I read the title is The Beauty and the Beast. Because the beast lives in a castle where all the personnel has been turned into furniture, but they move and talk and dance and entertain Belle. And but I think it really works it's evocative in this sense because what we want is a house that we can talk to and is going to do things for us. This is why IoT is developing. This is the dream of having the smart home like the Jetsons. And we still dream of, the robot butler. We still want that. But at the same time, like in every good fairy tale, magic comes at a cost. Sometimes it's a curse. Sometimes the price is quite steep. And it is the same with the smart home, and it is the same with smart speakers. And it does appear like magic to us because, as a famous writer once said, every form of complex technology appears like magic to someone that doesn't know how it works. But at the same time, it has a cost, and that cost is invisible or might all of a sudden become visible and then make us uncomfortable. And that is what happens with certain data collection inside the home with the IoT, the Internet of Things.
All right. Yes. And so, and of course, the word magic has, it's not just a way of thinking about it, because it might be that indeed in some country there is a magical relationship which might change the relationship with privacy. And so that takes me to what you've done in the first part of your PhD, in which you explore, as we discussed already, the way we've seen privacy through Western history, and what it represents for individuals and the values and the attributes that we attach to privacy. And so I'm wondering, what are the most surprising things that you've learned, when doing this part of your study, and how do you think this has impacted your legal outcomes?
Well, first of all, it's pretty obvious to all of us today that what was considered private 500 years ago, 200 years ago, or even simply 50 years ago is not the same than today. Or, as we just seen, what's considered private in one country is not the same in another. So this idea that privacy changes within a community and with time is intuitive, if we want.
But if I may, also really hard to measure, right? That's the joke of the two fish. I don't know if you know about this one, in the sea, and one says to the other, "Oh, the water is quite chilly today," and the other fish answers, "But what is water?" Because obviously they have no idea. And the same is true for us in culture and the way we see privacy. We live within that, so it's really hard to take a step back, which is why I think your PhD and this first part of your PhD is fascinating. But please go ahead.
No, but you're perfectly right. It's exactly that. These are things that somehow we recognize when we see them, right? We know intuitively what we want, and what I've really I've put a meaning to that intuitive idea that privacy changes with the context. And what really has emerged looking at behavioral sciences and philosophy, and also at some philosophy of technology and STS, so social sciences applied to technology, is that currently privacy is part of a negotiation between the individual and the community. And this is not something that we constantly do with intention. There are individual preferences, subjective construction, subjective understanding of what is private and what should be respected, that somehow create values, and at some point these values come to the surface in a community, in a society, and they also become an objective threshold. So there is this constant tension between the subjective and the communal, the objective dimension, the collective dimension that's recognized, the value and the clashes of values that are constantly negotiated with an individual. And definitely one of the things that I found more interesting is it's connected to this relational aspect of the private-public dimension, and it is how individuals enact on their privacy. So, and this is pure behavioral science. This is Irene Altman's theory, and all the scientists that work with him. We create a series of mechanisms and enact to have the social norms that implicitly exist in a community respected. So territoriality is one of those, where we cut off a territory, we put a fence, we build walls to protect the private life and the private sphere. Another one is purely psychological. It's called crowding, and definitely was one of the most interesting things that I discovered exist in other disciplines. Because crowding is the psychological perception, that we have less control on our private sphere following the presence of someone else. It is independent from the actual presence. It doesn't matter if someone is there physically, we can see them. If we perceive that there was a presence, we perceive the traces, that makes us more uncomfortable. And this is going to trigger our reactions. We might close the curtains. We might clean the house. We might go through and lock the doors and the windows. So it has a cost that is not only the cost of the curtains and the locks. It's not only economic. It is a cost at level of mental energy, psychological comfort, and finally, in terms of identity, being comfortable enough to disclose our identity and unravel, which is something that you should do in your private sphere, right? You should relax and let your true self out. And then when you go back outside, you have enough energy to interact with the community in a desirable way. So all these things that other disciplines tell the law, I think, are extremely exciting and interesting, because it also tells us what the law should protect.
But so let me ask you the following question, which relates to, and then I will move on to the legal part of your thesis, but the relationship with, our perception of privacy and the law, I think, is fascinating. And so would you say that we should not enact privacy regulations if it goes against, the norms and the desire and the way people perceive privacy? So in a sense, would you say that, that's the basic distinction between should the law be in advance from, for society, or just follow what people want? So what is your take on that?
That is very interesting, and it is a little bit of a egg and chicken question for legal scholars in general and lawyers in general. I do think that the law is an expression of a certain culture at a certain time, like literature and art. So in this sense, I think the law is the result of what has been boiling underneath the surface in the community and what has emerged. And technologies actually become very important in a dialectic process, because the law, I am very Habermas. I'm a fan of Habermas. So we have the public debate where all the individual subjective preferences are discussed and evaluated and clash with each other, and then eventually something is synthesized out of this, and that becomes the new threshold, the new norm, and that is going to be put into discussion again in a cycle. This is very dialectic, and I believe that this is how mostly the law also comes to be, regulatory interventions in general. And it is only one of the possible tools that we can use to protect an interest that we think deserves protection at societal level. And in this cycle, I think technology becomes very interesting, because technology can be a catalyst, can accelerate the clashes of values that were more dormant under the surface. We've seen that even with non-digital technologies. We've seen that with a lot of debatable and difficult choices in technology connected to technologies like pre-birth screening, right, or contraception. This technology brought to the surface different values that were clashing. And then from this clash, something new is synthesized, and then the law protects this new creation. So I do think that the law reflects this debate, this constant dialectic. And it doesn't mean protecting the majority always, because obviously by now, with the human rights framework, we know that a value in a society can also be the value of the minority, for example, or it means creating something new that can include both perspective, at least in part.
Yeah, and I was thinking, going back to Lessig's framework. So we have the law, we've been discussing that, the norms, we've been talking about that as well. Then you have the architecture or the technology, the design, and another one is the market. And it seems that potentially when you started your PhD and even when you ended the PhD, I mean, of course, you can't say the market was not relevant, because, of course, it's it makes companies make lots of money. But I'm not too aware of smart speakers that will be, that companies could say, if you buy this one, then we will protect your privacy, and this is the way that we used to compete. So that is our market approach. I'm not too sure about that. It seems, I mean, the one that I'm aware of is, as we mentioned, Google Home and Alexa and Siri maybe. And Apple would say I protect privacy a bit better. I'm not even sure if that is true. But have you seen, those market forces playing out and trying to protect better privacy? Or do you think this is something that is not here, but that will come? Or do you think we will never see that because it's not compatible to protect privacy and make those IoT function well?
There are experiments that are being carried out, but they're not really private companies yet. They're mostly experiments, or it's research and development from universities or projects of NGOs that are trying to create home assistants, voice assistants, or smart speakers that are a little bit more privacy friendly. So one was called Kendall and originated between, I think, the Netherlands and Germany. No, Kendall was in Germany, in the Netherlands. Germany has Magnolia, which is a smaller company, and Magnolia is the name of the assistant that is more located there.
So you would say it's coming, starting from public institutions to the market?
I think there is an attempt, but I don't think so, because of the way these kind of markets are structured. The winner takes all economy mechanism is very strong, like in many digital products. I don't see them to become actually that much relevant players outside of a niche of people maybe like me that are lazy enough to really want something like that, but obviously also work with privacy or are very privacy aware, and so would not necessarily go for the mainstream ones.
Yeah. So your perfection is more like search engine in a sense. Still, the main players are not super privacy friendly, and we do have DuckDuckGo and a few others, but they represent 1 to 2% of the market. So you would say the same will be most likely true for the smart speakers.
I think so. And that, I believe, is not just based on my own impression, but is informed by how the technology works, which obviously this is another thing outside of the law that I had to dive into and make myself familiar with. And also from the very markets, actually, meaning that I have looked at the business model of these devices. And for example, it's very clear in the case of Apple, because Apple One has the tendency to locking the customers and the users into their ecosystem of all their products. And obviously they don't want to be left out of that, because that might mean that some users might get outside of their ecosystem through the voice assistants. It's very clear in the case of Google, because it works with data and it complements their search engine. So it goes still in that direction. As a matter of fact, no one knows what the business model of Alexa is, which I think it's incredibly interesting. It was developed by chance as it's what's left of a previous project that didn't actually work and was a virtual reality project. Then they took Alexa, they separated it, and they created the smart speaker. They created Echo, the device, right? However, it also bridged a little bit the distance between Google and Amazon with regard to having access to data, because Google had an incredible access to data thanks to the search engine that made their AI, made their machine learning better. Now, Amazon with Alexa has bridged that because they have our voice data. So their AI is getting smarter and smarter. So we know it bridges a little bit that gap. We know that somehow it helps with online shopping on the Amazon web shop, but the sale of the device, even the cost, is not covered by the price.
Yeah.
So it is not clear yet exactly what business model they're attaching to it. And that is going to affect a lot how much privacy is protected there.
Indeed. And that is where the law comes in, of course. And again, I mean, I could do the same, criticism, which is that you are not in the future at the time you've written your PhD, because the DMAs will play an important part in which if it stays as it is, big tech companies won't be able to take some personal data coming from one service, such as the Echo, to improve another service, such as Amazon.com, which will be very interesting and would change the business model entirely. But something that you did cover is the GDPR, of course. And so I'm curious, what are the main takes away from your research when it comes to, the relationship and the way GDPR is governing smart speakers? And are you concerned? Are you satisfied? What can we improve? So what are your main takeaway from this second part of your PhD?
Well, in terms of GDPR, I do think in general it offers a good threshold for the protection. Of course, everything can be improved. And I am taking here the mere perspective of protecting personal data because they are a fundamental right. Because this is the reality of the law in the European Union, where personal data are not a commodity, they're not a good, they are a fundamental right, like privacy. So the threshold of protection here needs to be very carefully established. In terms of shortcomings, I think definitely there are some things that can be improved in the way the GDPR is interpreted or applied concretely to these devices. One of them that is more general and connects to what you're saying in terms of why can't we use the data from the voice records of Alexa to improve certain services on the web shop of Amazon. Technically, they can, and they're already doing it within the framework of the GDPR. They're already doing it because the main actors in this market, so Amazon for over 75%, 78% of it, and Google, have umbrella policies, privacy policies that cover all their services. So whether you're signing up for the email, the web shop, or the voice assistant, it's the exact same privacy policy you're agreeing to. It's general and it covers up to 62 services and the biggest of the two. So it's quite wide.
And of course, we've all been reading all of those privacy terms, right? Before using.
Not only. Recently, I think it was the end of 2020 that the French Data Protection Authority censored Google for the way their umbrella policy is formulated, because it's a website with a lot of short paragraphs and hyperlinks to these paragraphs where they have more explanation. The explanation is very generic and it's very diluted and fragmented throughout a lot of web pages, almost as if it was some dynamic forum situation. And actually, I have found myself that sometimes if you go in the true forum, like the developer support or the user support, you find better information than in the privacy policy. They're more detailed. So the French Data Protection Authority said, this is too fragmenting. You're actually hiding information this way. Plus, you are mixing together information for over 60 products and services. what can possibly the user understand from this? It's difficult. It's not
And
working very well.
and did they say this was a problem regarding GDPR or something? Okay,
This is
so
purely
GDPR
from the
here.
GDPR perspective, because the GDPR has an obligation of transparency of the controller, so the entity that is in charge of the processing, to inform the users. Then the users can make informed choice. That is the starting point. To the extent that a simple user can actually make an informed choice on a very complex technology, because there is also that. And there is an episode that really makes you understand the tension that is created between these devices, the GDPR, the practices of the sector, and the fact that we're talking about our homes. So it's a special place. So towards the end, in the middle of 2019, actually, some contractors of Amazon, so people that were working for another company, and then the company was working for Amazon, right? And some former employees of Google said, listen, our job was to listen to snippets of conversations recorded from the smart speakers, because in that occasion, the smart speaker did not understand the language. So there was a conflict to solve in natural language processing, which is the function that allows us to talk to us and understand what we're saying. And so they need a human intervention to solve that conflict, so that next time the speaker is going to perform better. It's going to understand it.
Basic deep learning. Yeah.
Yes. This is a practice of the sector. It's common. A lot of companies do that when there is a conflict in understanding and they want to improve the service. And in the privacy policy, it clearly says that the data can be used to improve the service.
Yeah.
However, these snippets that were up to 30 seconds long in some cases recorded fights, a possible aggression, sexual harassment. In some cases, they had names, addresses, and apparently, and this was not fully verified, they were not fully anonymized for some of the contractors. So the contractors had access to the address with like the civic number of the house in some cases. So they had the full profile of the owner. Now, this, I argue, is not in line with the GDPR, because the GDPR has a provision that says that technical and organizational measures must be taken to minimize the data processing. So these people should not have had access to the address. It's not the minimum amount of data necessary for that processing, and it's not complying with data protection by design. However, even if we want to stretch it and say the address is necessary to understand better what they were saying, for example, and we want to say, okay, we did inform users that we might use the data to improve the service, and this is what we meant. This doesn't remove the fact that the people learning this, the users, actually were not happy, and a scandal was created, and people complained to the newspapers because their private sphere, their home, felt violated. It was an interference. Even if they had some information, but that information was not specific enough, they couldn't understand the implications of improving the service. And even if we assume that we can stretch the GDPR and say that that is compatible, it's a sector practice, that does not remove the implications for our private sphere, for our home. So you see here how the tension is inevitable in certain things with these devices. The GDPR has a standard and a threshold. The sector practices might willingly or unwillingly not line up with that threshold. And at stake, there is the expectation of privacy that the citizens have inside their homes.
Indeed. And so again, the tension between the norms and the actual law. And eventually, if of course people expect privacy, then it means that the market will play into force. I was smiling because some members of my family do have such, I won't give names, but home speakers. And sometimes, when the discussion, again, I won't disclose the subject and it's nothing criminal, but sometimes when they do mention a few topics, they will talk like that so that, the speakers cannot hear what they have to say, which I found to be fascinating how, yes, again, it impacts our norms and our behaviors in a very practical way, which please, yeah, go ahead.
What your family members are doing is one of Altman's mechanism, strategies to reinstate a desired level of privacy. That mechanism, it looks trivial. They're just lowering their voice. But lowering your voice in front of a smart TV or a smart fridge or a smart speaker in your own house means that you're wasting mental energy and you are losing something in terms of feeling comfortable and emotionally connected to your own home. It has a cost. It's not that trivial.
And still, right? They keep the thing and they use it. So again, this is where I love those really uncomfortable questions where you will ask lawyers or people, well, what if people do want that? What should we do about it? This is why I ask you the question: should the law be always following people's desire, or should we go at someplace else and try to just follow what they want? So, but this brings me to my very final question, which is, what are the main open questions that were left that you were left with when finishing your thesis on such a vast and fascinating subject? Is there any question that you will address in the coming month and years? Some questions that you think are for others to address? So what is the landscape here?
I had a couple of open questions at the end of the research, and to be completely honest, those are probably the ones that get me more excited in general about my research. I was very happy that I found those questions. And one is connected to the GDPR, and it's pretty legal, but it also has an element of a reflection more at societal level. So the more and more we're going to be living into an environment, even a familiar environment like our home, that is embedded with these digital technologies, so the smart home or the smart city even, the more we're going to be constantly exposed to a series of optimized automatic decisions of these devices. We might give some inputs, but their algorithms are going to choose the optimal way to carry out certain things or certain tasks, or to achieve a certain goal. Mm-hmm. And they are going to profile us in a certain way. Now, the GDPR offers protection against these kind of automated decisions and profiling that can have either legal effects, so they might lock us out of a mortgage, they might, reject our citizenship or a job because of an algorithm selected our profile. Or they might have similarly significant effect. So they might affect us in an important interest, in an important right, like not being discriminated. Think of the case of the Asian families that were being given a higher price for tutoring based on the stereotype that Asian families want their kids to go to university more. That was happening in the United States a few years ago. Now, if we take the environment where we might have a lot of teeny tiny trivial daily decisions automated and optimized also to the interest of the company. So, price discrimination, maybe of a few cents on the groceries that we're doing through our smart speakers, can pile up in the span of a year or 2 or 5. And a few cents on every purchase becomes a lot in the end. Or, they might profile as more vulnerable to purchase certain goods and start serving us more ads about that. And that's going to make us waste our money again. Or discriminate us for other services based on what we did inside our house. Now, the starting point of the GDPR is that you have one decision that creates this big, nasty effect on our lives. But what when these big, nasty effects is the result of accumulation of teeny tiny daily decisions? There is no answer to that yet. And there are a couple of interesting cases, especially from the court of Amsterdam with Uber and the profile of their drivers and how they might be fired based on that profile. That might go in that direction, and I am following them close, and I hope to have more information from decisions in this sense. But that remains an open question so far. That was something that GDPR did not probably anticipate.
And something, and I couldn't resist but to talk about competition law just a tiny bit, because I think we should definitely cooperate on those questions. But when you were mentioning the fact that sometimes it is not in your best interest, but in the best interest of the company. I think this is where you could see competition law also playing a part. But this is interesting because it means that it could also be that in some occasions it is actually in your best interest, right? So if you just ask any home assistant, can you please order a pizza to me? This could be also very convenient as a consumer, which means that what you see is that the choice reduction, the fact that you don't even have to choose anymore, might be good for a consumer. It might be bad if it simply benefits the company, but it might be also convenient. And something which is fascinating is that in the space of competition law, what we see is that agencies assume that more choice is always in the consumer interest, when in fact, Home Assistant can increase consumer welfare by reducing choice and serving them what is best for them. But it, of course, triggers the question, is it really what's happening, or are they serving what is best for the company? So this is where the interplay between privacy and competition law, as I mean, we have a lot to learn from each other in the space. So I just briefly wanted to mention that, and sorry I couldn't resist.
No,
But
no, no, I absolutely agree. And sometimes we see privacy tools used with an eye to competition and vice versa, right? And the other open question that I had actually also has an element of that, where we have to look at consumer protection and competition law, I believe, to find some answers. Because what I've looked at in my non-legal part is, and that was another really fun discovery, is that all digital products are designed to optimize our reactions and persuade us. Some may say nudge, but nudge is a very specific concept in I feel economic behavior. And they might persuade us to a certain action or behavior so that we engage with them more. And we intuitively already know that because we say that some of these things are addictive. Right? It's not necessarily addiction. It's what they call long-term relationship with the customer. So it is, there are very simple tricks like a certain combination of color, offering a tip and then like a suggestion. The assistant might offer you a suggestion or do something for you, and then right after, when you're well disposed towards the assistant, ask you to do something else. And by doing things, they're going to collect your data, right? So they do get something. You contribute to them. This is a mix of marketing, psychology, and computer science, and user interface.
And of course, they could do certain strategies for certain consumers and all the strategy for others and compare the result, which is very convenient.
Exactly. So with machine learning and personalization profiling, this can be further refined. But honestly, I have looked so much into it, and even some very basic mechanisms. The simpler, the more effective, honestly. So if you put the banner of your favorite soccer team on a website, you're going to be more prone to answer more questions, for example, in a survey, things like that. It's an extremely easy thing. But definitely AI or machine learning becomes an enhancer of this. And what happens here is, so this persuasive effect of embedded in our home in a digital and physical environment, for me, becomes incredibly interesting because the law has not dealt with that unless we're talking about consumer protection with very clear-cut situations like the true subliminal messages that were very trendy in the 90s when I was little. We assumed that advertising was going to show us one photogram and that would going to push it and go buy a certain soda or something, right? So that is kind of a clear-cut situation. But this is less clear-cut.
And what about the AI Act? Because there are some provisions about that and manipulation. And one way of reading it is that advertisement is now prohibited in Europe, right? I mean, of course, this wasn't the intention, but advertisement is about manipulating people so that they will buy the thing. So I'm very curious of how they will frame that in a better way, because for now, I think it is very problematic. So I'm wondering, have you have a look into the AI Act? What's the interplay with GDPR? I mean, those are big and huge questions. The good thing for everyone to know is that we've decided we thought we would be doing a 20-minute interview, and it's been an hour, but it's a fascinating subject. So please go ahead, and I think we can wrap up after that.
Yeah, now, to wrap up, definitely the AI Act considers the subliminal effect to distort behaviors. These are very vague terms. So I am really looking forward to understand better how the European legislator intends those words, like what they mean for them, and how they want to apply them. And what you were saying is correct. We even have shops that place products in a certain way, so we buy them in the store, in the physical store, right? And that is allowed. So where do we draw the line between manipulative practices that are desirable or persuasive? I prefer a more neutral term for now, because it's still to understand what it is actually. So between the desirable and undesirable persuasive practices is exactly the answer that I want to answer, the question that I want to answer now in my next research endeavor. So I really hope to have an answer to that in a few years' time. But and I also think that that's going to affect also competition law a lot, as you were saying, because that can give quite an advantage at some point to some companies.
Of course. So people should expect paper from us both. In the meantime, I believe your PhD thesis will eventually be published. But for now, I'm sure we can find some of your open access articles on the subject.
Absolutely. And they can contact me on Twitter anytime. And I'm happy to talk about smart speakers a lot, as you can see from how long this interview was.
Of course. Well, thank you very much. It's been a fascinating discussion. And you can expect more talks coming from the ALTI team in the coming weeks and months. So, Silvia, I'll see you in a couple of hours. And thank you very much. Take care. And bye, everyone.
Thank you.
Bye-bye.
Bye.